if this was, as Jessica said, I think if this was a course in criminal law, we would take you in some details through a lot of these things. But it isn't. So I think all we want to do is give you the flavor of the things that go on in this kind of a trial, and this is where Matt will back me up, or maybe not back me up, but say I don't think it goes quite that way. It goes this way, and and I welcome that. I had another case where the sexton of a church went after somebody who'd thrown something through the church window, and he took a baseball bat and smashed the front of his car, and he was charged. And again, he was sort of a sympathetic character and thought he was doing the right thing in defending his church. And he did get taken right off. And I can remember seeing his face popping through the little hall as they take them downstairs in the courthouse in Montreal and said, "Mr. Paterson, who will look after my parrot?" Well, as it turned out, all the women of the church looked after his parrot. They took him picnic baskets every week, and it was the highest moment of his life then. But for me, it was devastating when he was taken away from his parrot in that abrupt fashion. And first of all, cross-examination. You're not going to have much time for cross-examination, as I understand it. Maybe 2 or 3 questions. It's hard to knock someone off their stool 2 or 3 questions, or to show someone's not telling the truth, etc., etc. So you have to really prepare this. You have to really boil it down to 2 or 3 things you think, without having heard. Of course, you have the advantage of all this stuff that's been written. You have a fair amount of information about what each witness will say. But just boil it down to something straightforward, simple, that attacks the credibility. That's about all you can do in that kind of questioning. And normally, to attack the credibility, we may ask the same question in different ways 10 times. We may go around in circles. You don't have time to do any of that. So you've just got to take a couple of facts and try and penetrate through and have the witness at least look less credible than when his or her evidence was given. You've got to really concentrate when the witness is testifying and take all the notes in the world that you need, and then pick out the things where you think the witness has made some obvious errors, will conflict with other people are saying, and go for them. If you put the witness in the box, you cannot ask what are known as leading questions. Think of it this way: if it suggests the answer, it's probably going to be a leading question. If the answer is yes or no, it's probably, not necessarily, but probably going to be a leading question. So you have the right to object if that kind of a question is asked to the opposite party's witness. Another example could be, did you, sir, attend at the Lion from 7 till midnight on February 1st? Illegal, because it suggests the answer. Were you at the Lion on February 2nd? Doesn't suggest that the person was at the Lion, and may be acceptable. Matt, do you want to add anything about leading questions at that point?
Well, I think and maybe we'll hear from the students when it comes to the objections that could be raised, but I think maybe one that's fairly general is hearsay. The testimony that comes up in court, because the witness's testimony is evidence being brought forward, has to essentially be from said witness. So the basic rule against hearsay is that you can't, as a witness or as a lawyer asking the questions of your witness, to speak to things that someone outside of the courtroom has said, discussed, elaborated on. And there are a variety of reasons we can get into as to why that evidence isn't necessarily allowed, with some few exceptions. But I think that's really maybe something to consider.
You can repeat something you've heard said, and the fact that that was said can be made proof of. The fact that what was said is true cannot be made proof of through a third party. You understand me? I mean, you can say, I heard George call Jim a liar. That can make proof that George did call Jim a liar. It doesn't make proof that Jim is a liar. But I agree completely, and we've told the judge, we shouldn't speak to him before the trial, but we don't allow this objection business to go on very long, because you can make an objection, you can talk for 10, 20 minutes, and people use objections not for the purpose that they're there for, but to pass a message to their witness. You know, if your witness is going downhill, there's nothing better than to slow the whole thing down by getting up and talking for 20 minutes about an objection while the witness is sort of rethinking what he said, and then when the next question's asked, maybe he gets back on track. You can't get into this in this trial at all, and your objection must be, it's a leading question, it's hearsay, it's whatever, for 2 sentences, the reason, and our advice to Golden has been, make fast work of those objections. Now, a judge can take under reserve his judgment on anything, and often they do in objections. Some lawyers will object to every question, okay, just constant, and the judge finally gets fed up with the whole thing. Under reserve, under reserve, under reserve, and then the lawyer starts looking like a fool and hopefully stops it. So the purpose, just quickly getting back to a couple of quotes on the cross-examination, the famous John Mortar wrote, cross-examination was not the art of exhibiting crossness. In other words, just screaming at the witness and badgering the witness is no way to conduct a cross-examination. Some of the most effective cross-examination, very quiet, very pleasant, gets the witness thinking that the lawyer is actually on his side. And he realizes he isn't, but just by talking to him quietly and nicely, he gets the witness finally to turn and give a different answer. And then the most famous, I think, is Marshall Halls, who said to a witness who broken his shoulder and claimed a very high damages in an accident, and he said, "Sir, how high could you raise your hand before the accident? And how high can you raise your accident?" End of cross-examination. Sometimes it's something as simple as that.
I was just going to add from a language perspective, and further to Alex's points, the idea of okay, we have X witness of the Crown, and we'd like a Y piece of evidence to come forward. I think just very basic language, like after the witness has answered your question and that's segueing into the evidence to be admitted, you can use something like, "Your Lordship, the Crown wishes to present the following evidence," or request that the following evidence be made admissible, and then the other side may or may not object to it. But I think it's always, because you're speaking to the judge when it comes to questions of bringing evidence forward, as opposed to speaking to the jury or to your witness, that's kind of, and Alec, correct me if I'm wrong, but I would say that that's really the style of language that you probably want to bring forward. And the defense is just the same thing. Your Lordship, the defense wishes to present exhibit, what have you, when we're presenting our witness.
I'm glad you hear it. The judge is either, when you're referring to Mr. Justice, or your Lordship, and stick within that context if you can. Badgering the witness is another one. If the witness is asked the same question over and over and over again, and it doesn't go down with the jury anyway, and it doesn't go down with the judge. So that's quite a popular objection. But that's it. I mean, it gets more and more polished. It's very sophisticated sometimes, but a lot of the time it isn't. It's almost common sense.
One other maybe time saver thing I was thinking about for both sides is when you're posing your questions to your witnesses, don't waste time trying to, I guess, dig into the veracity of their statements or how truthful they are, because in actual criminal trials, generally speaking, you can't bring forward questions or evidence that can be defined as oath helping. And so because we're so stressed for time, I would suggest that both sides almost really get to the point when it comes to what their witness is bringing to the table, as opposed to spending time about, they've done A and B and C in the community and they're generally truthful, et cetera, et cetera. Let's almost give that as a given and then get to the meat of things. The criminal justice system in Canada, that the right of the accused to take the stand or choose not to take the stand. And so unless he or she decides to put themselves out there, the Crown has no right to question, to bring them forward. That right to remain silent, essentially, it can be maintained over the course of the trial. So it's a very good question, but it's also something important to know that the accused can sit there, watch the whole thing, and not say a single word over the duration of their trial for whatever they're charged.
And that cannot be referred to. I mean, that's his right, and it can't be argued, well, because he didn't testify, he must be guilty.
Fairly recent Canadian case law history where the duty to disclose on the part of the Crown, and this duty being disclose everything to the defense, wasn't always there. And you only need to look as far as to the Donald Marshall inquiry and his wrongful conviction case and the Royal Commission and the changes to the criminal law system that happened after that to see how back in the day it wasn't just as though an accused had all the weight of the state up against them in the court, and while they had their rights to remain silent, but particularly before the charter, they also arguably could be going into trial without knowing everything that the Crown had on their side of the case. And so there have been very substantive changes in the last, I guess arguably the last 3 decades, reinforcing the rights of the accused to know everything that the Crown can bring before them at trial. So there aren't any of those aces up the sleeve that can be just dropped nuclear style. The accused has the right to know everything. And on the defense side, they have also the advantage of not necessarily showing all of their cards to the Crown. So for the purposes of our trial for Shakespeare, that doesn't necessarily apply, but the rules of disclosure from a criminal law perspective are pretty fundamental in the Canadian justice system. 2 major points, one general and one specific, in the sense that, very broadly speaking, just as Alex said, the judge needs to tell the jury the very fundamental principles of the presumption of innocence. The jury needs to convict on all elements of the charge on proof beyond a reasonable doubt. And those fundamental principles, generally speaking, ought to be put out there. And then you also need to speak specifically about the offense itself. So what are the elements of fraud as an offense in Canadian law? And with that information, in sort of the language that countless Supreme Court decisions have come forward with, in saying you're not using everyday language to describe what beyond a reasonable doubt means, but there are those templates from a number of decisions that Principal Goldblum can use, so that the audience can also begin to appreciate what it means to be a member of the jury and how a jury needs to reason in the environment of a criminal trial. And of course, we're dealing with the theatrical elements of it in the play, but I think it can be done very quickly, but can also be done in such a way to highlight the importance. Because in Canada's criminal justice system, jury charge or issues that are raised on appeal, so many of them at the criminal level deal with errors that may have been made to the jury in the judge's charge. So it's something to highlight, but it can be done too.
I think he says at the beginning, you are the triers of the fact, I am the trier of the law. I think that goes right up.
He does,
It's
yeah,
almost the
he
first
says that
thing
in the script, yeah.
But we really know defense is going to win. I mean, come on.
The trash talk begins.
I hope the lawyers have a good deposit for their fees. It doesn't sound like it's going to go far.